wind farm. Sorry, I should have said, I think Callum's checked that everyone can hear, but well, obviously if you can't hear, it's going to be quite hard, but I think no one's having any difficulty that I can see. Good. My name is Robert Seaton, and I'm the reporter appointed by the Scottish Ministers to hold the inquiry and to report to them with recommendations on the application. The inquiry is required by law. This is because Highland Council, as planning authority, has objected to the application. The purpose of this meeting is to determine the procedure for the inquiry. So just to confirm, as I set out in the agenda, that the merits of the application aren't to be discussed today. So just, I've introduced myself. I'll ask the parties to introduce themselves, or at least I can, perhaps make it a bit shorter. I recognise Mr. Trinick, Marcus Trinick QC, who is representing, I believe, the applicant, Kirkan's Wind Farm Limited, and I believe you have with you Elizabeth Tainch and Amy McDougall, and representative of the who are your instructing solicitors, and representative of the applicant, Mr. Trevor Hunter. That they're all here. I take it, Mr. Trinick. Yep. Oh, I think you muted, Mr. Trinick. Yeah, that's grand.
Yes, all correct.
Yeah, I can hear you now. Good. You were quite faint there, actually.
Can you hear me now? Is that better?
Yes, I can hear you. Yeah, that's grand.
I'll
yeah,
turn up
good.
the volume a bit.
Good. And I recognise Mr. James Findlay QC as well. And you are representing Highland Council and Nature Scot, and you have Karen Lyons and Simon Hinson from Highland Council, and Debbie Green and Anne Brown from Nature Scot. That's correct, Mr. Findlay, is it? Yeah, good. But perhaps if you just say yes, so I can just check. Yes. I can hear you. Yeah. Yes, good, good. Okay. And Mr. Aidan McCorkle from Scottish Environment Protection Agency was going to be here. You're here, Mr. I can see your. I can't see you on the camera, Mr. McCorkle, but I can see you're there.
It's Mrs. McCorkle.
Oh, Mr. McCorkle.
Yes,
oh,
I'm
goodness,
here. Thank
I'm
you.
sorry.
Happens all the time.
Hello. And Dr. Marilyn Hedger, who was also going to be here, who is objecting to the proposal. Is Dr. Hedger here? Well, possibly she's had some problems connecting. Callum, have you had anything from Dr. Hedger?
I've not heard anything this morning. There was a test done with Dr. Hedger yesterday, so I'll just resend the link to them and see if they can join. Right.
Okay. Grand. Well, there's perhaps some things we can deal with before we get into the kind of nitty-gritty of it, and perhaps Dr. Hedger won't resent us pressing on with those matters. Well, we'll maybe allow 5 minutes to see if Dr. Hedger does join us. Is that okay with everyone? Yeah. Okay, we'll just take 5 minutes, so till 10:10, and see if Dr. Hedger does join us. Is that all right? So that's 10 past 10. Callum, have we had any sign of Dr. Hedger?
I've just had an email from her saying that they're trying to join. They've only just received the link and they're having similar problems to their test yesterday. So I'm just going to get back to them and try and get them on as quickly as possible.
Okay. Well, we better wait for them if that's the case. So everybody, if you can hear me, I'll come back in about, well, let's say give another 5 minutes to 10:15, and we'll try again then.
Morning, Dr. Hedger. Can you hear me okay?
Yes, thank you.
Yep, perfect. Thank you.
Hello, Dr. Hedger, is that you? Dr. Hedger, can you hear me?
Yes.
Oh, good. That's you. Good. Well, just to introduce myself, I'm Robert Seaton. I'm the reporter appointed by the Scottish ministers to report to them and make recommendations on the proposed Kirkan's wind farm. Good. And with me, you see on the screen, Marcus Trinick, QC, who is representing the applicant, and James Finlay, QC, who's representing Nature Scott and the Highland Council, and Aidan McCorkle from SEPA is also here, the Scottish Environment Protection Agency, as I'm sure you know. So The other person who is going to join, the other person who is opted into the inquiry is Dave Gordon from Mountaineering Scotland, but he's not able to be here today, but he sent some written comments which we can take into account. Okay, I was just going to give a rundown on the law and practice relating to inquiries into applications under Section 36 of the Electricity Act. Essentially, there are the Electricity Act is the act under which the application is made and under which the inquiry is held, but there are no very detailed provisions under the Electricity Act on how an inquiry is to proceed. For that reason, the organisation to which reporters belong, the Planning and Environmental Appeals Division, some time ago produced a code of practice for handling such inquiries, and that's what I propose to follow. I should perhaps have sent out a link for this meeting to the code, but I can send you a link after the meeting with the note of the meeting, just to explain broadly how the procedure works. Essentially, the approach in the code involves our reaching an agreement on the topics that need further procedure in the inquiry, need to be investigated further, in identifying the appropriate procedure to deal with them. And there are several options for procedure, which I set out in the agenda, but briefly they are: you can hold an inquiry session, which is the most formal procedure, which works rather like a court. So parties provide witnesses who give evidence for them, and the witnesses may be cross-examined by opposing parties. The other option for procedure is a hearing session, which is a form of oral procedure, and it involves a structured roundtable discussion led by me on the particular topic at issue. And there's also the option of having further written submissions rather than an oral procedure on any particular topic. And you'll see in Annex 1 of the agenda that I suggested a number of different types of procedure for different topics, but we'll come on to that. The other piece of legislation which affects applications under the Electricity Act is the Electricity Works Environmental Impact Assessment Scotland regulations. So the proposed development needs environmental impact assessment. That means ministers have to reach a reasoned conclusion on any significant environmental effects that it has on the basis of information provided to them by the applicant, and in response to the application and in the EIA report and from this inquiry. There are some formalities to environmental impact assessment that don't always sit easily in an inquiry context. And in particular, where an applicant wants to provide additional information to supplement an EIA report, it generally will have to do so through a formal process in which additional information is advertised to the public for their comment and consulted upon with statutory consultees. And just to move, this is moving into the next item on the agenda. We have received additional information yesterday from the applicant. The point to make here is that the period for responses to the additional information is 9th of November this year. And so that's effectively another procedural stage in the run-up to the inquiry. So just having a look at agenda item 4 was about the applicant's additional information position statement. So as I say, it was the additional information to supplement the environmental impact assessment report was submitted yesterday. Just in terms of its substance, I had understood from the applicant's earlier position statement back in March that the additional information would include an alternative layout, but that's evidently not now being proposed. Is it, Mr. Trinick? No. No.
That's correct.
So what's proposed in the additional information is, or the changes to the development proposed in the additional information are those set out in paragraph 1.2 of it, which are amendment of 2 turbine locations, further information on public access to land, further landscape and visual assessment, particularly related to the the change in turbine locations and cumulative effects, and further information on noise. And I understand the applicants placed the relevant statutory notice in the newspapers with the deadline for comments from the public, which I say is 9th November. And I understand also that the additional information has been set out to statutory consultees, including SEPA. Now, the other thing I wanted to mention was that there are obviously a number of objectors, not all of whom are opted into the further procedure in the inquiry. And I was going to ask the case officer just to send notice of the additional information to those other objectors. I don't think there's anything controversial with that. Obviously, most people at this meeting won't have had time to look in detail at the additional information. But just in terms of its submission, I wondered if there's anyone who wanted to raise any kind of procedural matter or other similar matter about the additional information at the moment. Or Mr. Trinick, is there anything you want to say in respect to the additional information before anyone else does?
Just so that it was intended to submit this in September. We were hamstrung at the time of preparation still by restrictions on site visits due to COVID through the summer. I'm afraid that has delayed matters. In terms of the information on lighting, we have been mindful that there is an evolution of a position on the part of relevant bodies, and try not to give evidence, in terms of radar activated lighting. And we want to try and represent the latest position, which we believe we have now done. So those are the reasons for the delay. Nevertheless, the delay is regretted.
Well, thank you for that, Mr. Trinick. That's helpful. I do have a few further questions about lighting, but I think I'll let other people speak first. Mr. Finlay, were you wanting to say something?
Yeah, just this, that understand Mr. Trinick's point about delay, but the fact that it's come in at this stage presents, I think, possibly both parties I have responding.
I'm sorry, I didn't quite catch that.
It presents both parties for whom I represent with potential issues of responding in time. I'm really just a matter that occurred to me now is whether it was possible to seek an extension by a week of the time limit to prepare a response. We are, particularly Nature Scott has.
I see, right, okay. I mean, I don't have a particular difficulty, I think, with an extension in responding to the additional information, unless Mr. Trinick has a concern about that. My only concern is that timescales get rather short for doing anything. But given if we are going to have an inquiry in January, but I think Mr. Trinick.
So I'm less worried about the statutory timescales for responding to the AI and more concerned about people's time preparing evidence for the inquiry or coming to positions for the inquiry. I'm happy to agree any length of extension at this stage if it helps other parties. It doesn't really matter to us. What does matter is knowing by a reasonable date, and I'm aware in saying that of the delay in submitting the AI, by a reasonable date of Nature Scott's position on the lighting issue. We will work with them to provide them with what else they need to achieve a position, to knowing SEPA's position in relation to turbines 4 and 7. Those are the key issues. Otherwise, I don't expect the views of the parties to really change. The update in terms of cumulative landscape and visual assessment is simply an update. It's no more than that. So it's lighting and peat where I think there may be issues of timing, and we'll play along with what people want.
Well, I'll ask the views of others first before we reach any final decision. So, Ms. McCorkle, do you have anything you want to raise about the additional information? I mean, I was wondering if you could say if SEPA has any response in substance to the additional information yet.
Yes,
I know it's very short notice.
That's fine. We received the additional information on Wednesday, so I have had an opportunity to have a quick look at that. So I'll just say in summary, we contacted the applicant via email on the 16th of July after we heard that an application for appeal had been made. And we organized a meeting with the applicant on the 30th of July to discuss outstanding issues that we previously had on the application. There were 2 turbine locations that we were objecting to that were outstanding. And we quickly resolved these issues and the turbine locations were to be moved. So on Wednesday, we received the additional information and we can confirm that figures 2.1 and 2.2 reflect the agreed changes that we requested. So we actually have no further outstanding issues. And we will follow up with a formal written submission to the additional information. But we do feel that we don't necessarily need to partake in any formal inquiry process as the issues relating to our agreement have been satisfactorily resolved at this point.
Right. I wondered if that might be the case, but that's very helpful of you to say so. Good. Okay, we'll look forward to your written submission. There's no requirement that you should take part in the inquiry. I'm not going to cite you. So I think on that basis, I think yeah, that issue is probably dealt with. Yeah. Okay. Or at least your objection, that's your position on your objection at least. Okay. Right. Dr. Hedger, obviously, I don't know if you've had an opportunity to look at the additional information at all. It was flagged up that it was coming, but
I did have a go at wading through. I think, would it be helpful I just say where I'm coming from in all this?
Of course, yeah.
Bit of an introduction, because I kind of feel I've got to justify my presence.
Not at all, no.
Well, I first learned about this whole development when I was then a member of the Community Council for Lockroom. I'm not any longer. I actually live on the edge of the wilderness areas affected. I travel past these turbines 2 or 3 times a week. My concerns have always been about the impact on the visual and landscape impact. So that's where I'll be focusing on in the inquiry. Range assessment. I'm a long-standing member of the Royal Town Planning Institute. So I've had long-standing involvement in wind farms. In fact, going back to Wales and Mr. Trinick, actually Mid Wales a long time ago.
Were you involved in the Mid Wales inquiry?
Sorry?
You were involved in the Mid Wales inquiry?
One of them, yes, in yes, near McCuntleth. I wasn't involved, but I knew all about them.
Ah.
Right, because anyway, so that's where I'm coming from. So I mean, it's not the climate change arguments, you know, that is not the issue here in my view.
Vote key, I forgot the vote key.
Sorry?
I think that's maybe some background noise from
okay,
here.
all right.
Or
Anyway,
else.
I've nearly finished, don't worry. But I have real concerns about the visual impact. I also was very much aware that there were no public meetings in the Ullapool area. They were only in the Garve area at the outset of all this process. And I'll be taking soundings on that before the inquiry. And yes, I have concerns about issues about precedent, the evolution of these wind farms. You know, they're going up to 175 meters now, but who knows what will be wanted in the future. I'm very much aware that really the future of wind farms now is, and also renewable energy, is the marine and offshore developments.
Mm-hmm.
So there we are.
Okay.
I did have a look at the new submission, and I'll have a look at it in so far it's relevant to the main gist of my issues before the inquiry, but I don't need to say anything else there. Obviously, I'm talking in more generalities than technical specifics.
Right. Okay. There's possibly some elements there, both for the I've suggested, well, I'll come on to this, but for the inquiry, I've suggested topics for the kind of landscape and visual effects of the proposed development.
Yes, I saw that. Yes.
The effects on wildland and on
yes. That's why I said I'll be
policy.
commenting there on the inquiry. So I needn't send them today. I said what I'll where I'm coming from and where I'll be focusing at the inquiry.
Great.
Thank you for the opportunity to speak.
Yeah, I'd seen you were a member of the RTPI, so I assumed you probably had some inquiry experience previously. So
well, yes, I mean, it's on planning policy and the rest of it. I haven't been active. I've been working on climate change since 1995, so not on global policy and climate change, so not on UK land policy.
Right. Okay, good. Okay, I did have some further questions about the aviation lighting issue. So I think what I understand has been described in the additional information is that there's the proposal now is to have lighting on 6 cardinal turbines rather than on all 17, and that the lights would be dimmed to 200 candela rather than 2000 candela when visibility exceeds 5 kilometers. So that's all correct, isn't it? Is it, Mr. Chinnick?
Yes, sir. Just slight correction that the lights would in any event be dimmed to 200 candela when visibility is more than 5 kilometers in all directions from the wind farm. That's not a new concession. That's always been the case.
All right. I'm sorry. Yeah. Okay. That's an agreement with the CAA. That I take it the Ministry of Defence is on board with that too.
Not necessarily. The position is the CAA is now, by a letter dated 1 October, which I think has been, well, we'll make sure it's sent to everybody, have formally confirmed their acceptance of the reduced lighting scheme which you described, which involves single 2000 candela dimming to 200 candela lights on the hubs of turbines 1, 3, 7, 10, 16 and 17. No intermediate level 32 candela lights, so there'll be 6 lights as opposed to 68 lights. That is the reduction we're looking at in the number of lights.
Yes.
Some were anyway of lower source brightness, the intermediate level ones. They would be on all the time in night hours, that is to say in a half an hour after sunset until half an hour before sunrise, unless the radar activated lighting scheme is approved by the CAA, which is not yet the case. We're in discussions. I think we made that clear in the AI. And unless the MOD, for their own military as opposed to civil purposes, are content that their pilots can deal with radar activation as opposed to the lights being on all the time. So there are 2 sets of discussions going on, one with the CAA and one with the MOD, and that's evolving. We can do no more than try and speed the process. If we reach,
but in terms of lights being on the cardinal turbines, well, it would be useful just to clarify that the Ministry of Defence would be content with the particular scheme that the CAA is content with.
I see what you mean. Yes, they are content with that. They're content with the 6 turbine lighting scheme. Right. It's the further evolution represented by radar activated lighting, where discussions continue. But you will have noted that the AI assesses matters on the basis that such agreement will not be reached in time for the inquiry, and therefore the lights will be on all the time. If that changes, well and good. We can't promise anything.
No, I understand that. That's good. Right. Mr. Finlay, I mean, obviously, you've only seen this. You only saw this yesterday. I don't know. Is there anything in substance on the lighting scheme that you can say now about any change in the position of either of your clients, or you just simply want to consider that?
No, we need to consider it.
Right.
And indeed, that's one of the reasons I've asked for an extra week. And I can say, what I can say is this, perhaps, is that it's not going to, Mr. Chinnick's right, it's primarily going to affect Nature Scots rather than Highland Council.
I'm sorry, I'm not really catching what you're saying.
it's primarily going to affect Nature Scott's view rather than the Highland Council's view.
Right. Yes. Yes. Indeed. Yeah. Okay. Now, the other thing that came in last is there anything further on the additional information? Does anyone want to raise anything further on that? I just want to say something briefly about the position statement. Nope. Okay. So the other thing that the applicant provided very helpfully last week was the position statement. And the reason I'd asked for it was primarily to help me prepare for this meeting. Nonetheless, it does include a summary of the applicant's understanding of the party's objections and the applicant's response to them. I just wanted to ask, do opposing parties think that there's a need for you to have an opportunity to respond in writing to that, or are you content simply to deal with anything that comes up in the position statement in your evidence to the inquiry?
In the evidence to the inquiry, there's no need for a further step of procedure at this stage.
Good. Okay. The other thing I'd asked for clarification on was the BT response to the application and whether they'd actually been aware of the proposed location of the turbines. Now, I've seen an email to BT asking them about the positions of whether they're content with the particular positions of the turbines. So I take it there's no further response to that.
That's correct. So the email what you're referring to, let's check we've got the same one, is from Amy McDougall, the 24th September.
Yeah.
And we have had no response. We have those sent the AI to BT anyway. Of
course. Yeah. Okay. So hopefully we'll have a response to that in due course. So just to come to the issues that require further procedure at the inquiry. So I set those out. I set out my thoughts, at least in an annex to the agenda. And since then, we have had some helpful comments. Now, Highland has suggested that policies should be dealt with by written submissions. That the effects on wildland and landscape and visual effects, so effects on wildland, effects on landscape and visual effects should be dealt with in separate inquiry sessions. And I think Dave Gordon from Mountaineering Scotland said he was content with that approach so long as Mountaineering Scotland could give its evidence in the landscape and visual session. For me, I don't have any strong feelings about the separation of wildland and landscape and visual effects. So I'm happy to have those as two different sessions. Do you have any views, Mr. Trinick?
I'm happy with either. Okay,
good. Dr. Hedger, do you have any views on that? Are you content to give your evidence in the? I think you probably want to be involved in both parts.
Yeah, I obviously there'll be quite a lot of overlap, so it's up to you, I think, and how you manage it. Yes.
Right. Okay. I mean, I suppose Mr. Finlay.
Yeah, it's just this that given the new information, it may be, and I stress it may be, that Nature Scott will not be playing a part in the inquiry session. And if that's the case, then neither party whom I represent will be leaving evidence on wild land.
Ah, right.
And in those circumstances, in our view, it supports the suggestion of splitting or having two sessions so that if particularly a hedger wishes to be involved in the wildland session, she's aware that she may be the only person involved in wildland. But otherwise, in terms of landscape and visual, I can assure everyone that Mr. Heinsohn will be our witness and we will be giving evidence.
Right.
I will be leading evidence on behalf of Highland Council.
Right. Well, perhaps we can deal with it on the basis that we will. Oh, Mr. Trinick, yeah.
Yeah, I just need clarification on one thing. I think Mr. Finney provided it, and my apologies if he did and I didn't pick it up. But with regard to wild land, Nature Scott's only objection is on lighting issues. The terms of the objection by Highland Council allow room for an interpretation that they object to the effects of the development on wildland in daytime as well. But what I just understood Mr. Finley to say is that if the lighting issue is resolved, then neither of his clients will be making a case on wildland. Is that correct?
Yes, I understand that, and I use the term broadly, both my clients had concerns about the daytime effect, but it would not lead to an objection by Nature Scott. And if Nature Scott withdraw their objection, Highland Council do not intend to leave separate evidence on wildland. Their concerns, as I understand it, simply reflected the concerns from Nature Scott, but there would be no objection on wildland. That's my understanding. If I'm wrong, no doubt Mr. Hanson will contact me and put me right, and I will let you know.
Well, I'm sure that's right. The leading on from that, sir, I have a question for you, which is that if, and obviously you'll need to hear from Dr. Hedger on this, and her evidence is important in this respect. She may be the only witness on wildland if she wants to give evidence on wildland. But if nobody wants to give evidence on wildland, will you nevertheless want to receive evidence from the applicant on the topic for discussion at the inquiry? Or can we focus on non-wildland issues? It makes a difference in terms of our preparation. It makes a difference in terms of your site inspections.
Yes, yes. Well, perhaps, Dr. Hedger, were you proposing to give evidence particularly on wildland?
Well, I thought the Mountaineering Council wanted to give evidence on wildland. Did I miss that? Or did I get that wrong?
I understood them to be giving evidence on the landscape and visual effects in particular.
Okay, all right, I missed that.
And a particular view on the landscape and visual effects.
Well, I don't see any point in having a separate thing on wildland if I'm the only person involved, but I would certainly make comments in relation to wildland in following on from landscape and visual effects in that session.
Yeah. Okay, that's very helpful. As regards my satisfying myself on wildland, can I respond to that in the note of this meeting? I think it's unlikely that I would want further evidence if there's no objection on wildland, but I'd like to have a further look at the material if that's okay.
That's fully understood, sir. I just want to be sure that Dr. Hedger doesn't feel put off by the fact that she may be the only witness. I would hate to see her shut up in any sense.
Can I just make another point? Yeah, I personally think you should go and have a look at some of the wildland on a site visit, I have to say. I think it's quite important for understanding this. I'm happy to touch on wildland in relation to landscape and visual effects in that session. So that's fine. I don't see any point in having a separate session on it if I'm really the only person standing up with that banner, only that banner.
Perhaps the solution, Mr. Trinick, is to prepare on the basis that there would be evidence on wildland from Dr. Hedger, and we would, if there is not a continuing objection from SNH, we would deal with it in a single session with landscape and visual effects. Does that work for you?
Either that or we have an exchange of written opinion on wildland and don't put it into an oral session.
Yep. Okay. Well, I'll take that away and consider it, and I'll have a look at the wildland material myself. Good. Okay. But it's all predicated on whether Nature Scott will continue will maintain its objection or not on wildland. Yeah.
And also, sir, on the evolution of CAA's and MOD's position in relation to radar activated lighting, and we'll keep parties rigorously up to date on that.
Okay. Right. Okay, so the other point was whether policy could sensibly be dealt with by written submissions from Highland Council.
So perhaps I can expand on that. We've just finished a, well, we haven't actually, but we've dealt with part of a hearing session on Drumholliston 2, where policy was dealt with by an exchange of written submissions, which didn't lead to full agreement, but clearly narrowed the issues probably to a point where closing submissions could be made on them. And the reporter there felt there was no need for a policy hearing session. In our submission, that Drumholliston also had a wildland aspect to it as well. That was a more efficient use of time and resources, given that the policy positions of the parties, particularly in Highland Council, but with respect to both sides, are usually fairly well honed, and there is obviously a matter primarily for you as to whether you would find a hearing session of assistance. The procedure adopted before the Drumholliston 2 reporter was to have the exchange of submissions and then leave it open to her in that case, and our submission would be to you in this case, to have a hearing session if you felt one would be helpful to you, but not to have one as a matter of course. And our approach was the same in respect of conditions. Again, in that case, the conditions were agreed between the parties, and there's usually there's an expectation that, but not a certainty that that would be the case here. We, I think, mentioned in our email that we would use the Galty clay conditions as a starting point. And again, if there was agreement, it could then be left to you whether you would wish a hearing session to discuss particular conditions or not, as the case may be. But again, no necessity for having a condition session as a matter of course. And we have some time between now and January in which those exchanges could take place, and you could review matters. If there is a need for a hearing session in either case, it's unlikely to be very lengthy, one would hope, for the reasons I've just indicated, and it could be easily fitted into a timetable. That's our preference and our reasoning for it, and it seemed to work reasonably well at Drumholliston. Right.
Okay. Before I come to Mr. Chinook, Dr. Hedger, I think some of your concerns touched on sort of policy matters. I think you'd mentioned things like the balance of onshore renewables and marine and offshore renewables, which would seem to me to be an issue that's more about policy than about.
I don't think. I mean, I don't think I can take on Scottish Government energy policy. I mean, I'm not intending to do that. I was just trying to, I suppose, increase the context for the decision making. I can certainly have a look. I haven't had a chance to have a closer look at that policy recently, and I take your point that I need to do that. But you're going to have a hearing anyway, aren't you? So I can presumably let you know nearer the time how I want to be involved. I mean, if they, I mean, I wouldn't have a problem if the parties decide to go through written submissions on that. I can involve myself in that. process.
Okay, well, but that was the question I was going to ask. Yeah. Okay, Mr. Trinnick, do you have a view?
Yes, sir, I do. Taking Dr. Hedges' point first, I would hope we're not going to get an agenda item at all which deals with the balance between onshore and offshore. It really would be digging into the merits of energy policy of the Scottish Government. I don't think that would be appropriate. So far as the method by which you receive evidence is concerned, I would be very worried if any decision was being made on the basis of the use of time and resources. That's not the important thing. The important thing is, do you get what you want out of whatever process is adopted? As to Drumholliston, I don't know what evidence was given there. There was a different policy witness, I understand, not the one we're using here. I don't know if we would agree with what they said. I'm very happy to hear that Highland Council did agree with what they said, but that's making a presumption I can't accept. I also note that Drumholliston was a Town and Country Planning Act case, not a Section 36 case, where other considerations do come into play, not least the applicant's right to a certain extent of oral representation at the inquiry. In terms of what you need to hear, there is MPF4 coming out in draft, and that will be with us by January. This will be about the first inquiry where MPF4 in draft needs to be considered as a draft. It may say some very new things. You need to hear those, and I think they need to be debated. I strongly feel they need to be debated in a hearing session. I don't think we're going to disagree with anything with Highland Council when it comes to their development plan, nor on energy policy, but it's on national planning policy, and it's a rapid evolution over a period of years that I think that you need to hear what we have to say by way of an oral session. My final comment is my experience of recent inquiries going back over the last year is that oral sessions for policy have been extremely valuable in digging into people's thoughts and revealing nuances that we didn't suspect exist before that hearing session. So I really am strongly of the view that we should have a hearing session.
Okay.
Can I just make one little point?
Dr. Hedger.
One quick point. Yeah, I think I touched on those issues about broader energy policy in my introductory thing, because I was very much aware that a very large number of replicated supporting letters for this development in the body of evidence on the basis of climate change policy. So I was just trying to, that's why I made the point. There are other issues in relation to climate change policy.
Okay. I think I'll take this week and consider it further. Mr. Finlay, do you want to come back on that?
Just 2 points. I don't want there to be any misunderstanding. We didn't agree absolutely everything with the drum policy, but the areas of disagreement were appropriately in the position that.
I'm sorry, I'm losing your sound.
The reporter no doubt considered that submissions could be made on them, closing submissions. The reporter did not need to ask questions of either party to ascertain their position. I understand what my own friend Mr. Trinnick says about the forthcoming draft MPF4, but again, in our submission that could be dealt with in writing, but I made it clear that I left open the possibility of you requiring a hearing session, and that may be one of the reasons for requiring a hearing session. But the purpose of this exchange of written considerations was to enable the focus of any hearing session to, well, the scope of any hearing session to be focused more, and to assist you in focusing it more acutely on the matters that you may wish to hear. And indeed, it may be MPF4 is a topic on which you do wish to hear, but it could be limited to that. It's just simply seeking to make efficient use of time and resources in a general sense without restricting the applicant's ability to present their case fairly.
Mm-hmm. Mr. Nick, I'll take a final comment from you if you wish to say anything more.
I'll just be repeating what I said already, and
right.
I note and obviously respect what Mr. Finley says.
Right. What would you on a particular proposal put forward by Mr. Finley that we should simply have hearing statements and proceed with the hearing if necessary? Would you be content with that view, or is your view that it's inevitable that a hearing will be necessary?
No, sir, I'm afraid I'm of the view that there should be a hearing session, which I think will usefully inform your report to the ministers.
Right.
Necessarily inform your report to the ministers. That strong a view on the topic.
Right. Okay. Well, I've heard your views, so I will resolve that in the note of the meeting. I think I am likely to go with Mr. Trinick's view that if the applicant considers a hearing session is necessary, we should have a hearing session. But I'll consider that further. In terms of participation and on the assumption that sorry, the other aspect of it is which I've passed over is the condition session. Do we feel the need that for a hearing session on conditions? I know a hearing session on conditions need only be pretty brief in any case, but and traditionally I think it's the planning witness who appears at the at a hearing session on conditions. I don't know if you want to be drawn on whether the Galta clay conditions should be the basis of it, Mr. Trinick.
Well, sir, I'm happy to respond on both points. I think adopting the phrase efficient use of time and resources, so little time is spent in the conditions hearing session that it's actually better to get just to talk about it then and there rather than exchange in writing. I think it's very kind of people to offer us another set of conditions, but I'm not acting for the Galta clay applicant. I'm acting for this applicant. And this applicant has its own view of what may be appropriate conditions. So thank you, but no thank you. We will draft conditions and we will submit them for the views of Highland Council and all other parties, and we welcome their views, and we'll try and reach a high level of agreement before the inquiry.
That would be very helpful, certainly. Just to, I'm sure you're aware, Dr. Hedger, that the conditions are discussed because this is a report to ministers. Ministers, if they wish to consent the application, would need to have a set of conditions there. So the conditions are discussed without prejudice to Highland Council's position objecting to the application.
Yes,
okay.
I understand that process.
Yep.
Thank you.
Good. Sorry, one more point on your Annex 1. You passed over the issue of public access to land.
Oh, yes. I did, yes. I'm sorry.
That topic is covered in AI. So we've set our stall out. You may wish to invite written submissions on that topic. It's up to you. We're frankly agnostic as to where you take it from there.
Yes, I'm sorry. I did have a note. I was going to propose that should be dealt with, or simply subsumed in the process of responding to the additional information. I suppose the only issue is that obviously what I've said about the additional information is that there's a statutory period for responses to that from the statutory consultees, of which Scotways would be one. I've said further that the applicant's opportunity, or we've agreed that the applicant's opportunity to respond to any comments on the additional information would be in evidence to the inquiry. If there's not a formal opportunity in the inquiry to respond to Scotways, I suppose that might put you in some difficulties. But I imagine we can deal with that at the time if there is a continuing objection.
So if you simply put in your note that we have the right to respond during the inquiry process in writing to any responses we receive to the AI, that'll be fine.
Okay, right. is everyone content with that? Yeah. Okay. The next item on the agenda is the participation of interested parties in further procedure. In terms of the people representing the parties, I understand that Dave Gordon will appear from Mountaineering Scotland, and if there are separate wildland and landscape and visual sessions, he'll appear in the landscape and visual session. Mr. Trinick, I assume that you're representing the applicant at the inquiry, and Mr. Finlay, I assume that you're representing the two parties you're representing here. I did set down in the agenda the scope of evidence that each party will lead and what witnesses will be called. As a question, are you able to say now, Mr. Trinick, what the scope of evidence will be for each topic?
Not in detail, so no. I mean, for landscape and visual effects, it'll be the normal scope of evidence.
Mm-hmm.
If wildland is required, that will be the normal scope of evidence.
Mm-hmm.
I have a single witness for both topics, Mr. Denny.
Mm-hmm.
He will take approximately 35-40 minutes in chief, and I anticipate cross-examining Mr. Heinsohn for about a maximum of 2.5 hours.
Right.
That gives you some indication.
Okay. Mr. Finlay.
Frankly, I think it's too early to say. I'm not even in a position to commit, as Mr. Trinick is, as to terms of timing.
Right.
It will only be Mr. Heinsohn that I lead on behalf of Highland Council on landscape and visual, and it would be Catherine. No, it won't be Catherine Harry on behalf of Nature Scott. But I'll reserve my position as to Nature Scott even more generally, because they have to take a view as to whether they wish to object or not.
Mm. So, obviously with the additional information, parties do have to take that into account and determine their position in respect of it. I wonder, I had said at the beginning of the process that perhaps we could dispense with statements of case for the inquiry sessions, but perhaps it would be a good idea at the time that responses are made to the additional information that we could have statements of case at that time too. So an inquiry statement simply setting out, giving fair notice of each party's position, setting out what witnesses they're going to have, the witnesses' qualifications, and so on. Would that make sense?
Yes, it's fine.
That's fine, sir. I just don't want to build in unnecessary elements in the process. I think we know tolerably well what Highland Council's case is going to be anyway on landscape and visual effect. The only unknowns are Nature Scott's position, which is either as it is now, in which case we know what it is, or it's not going to be there at all. Dr. Hedger, I wouldn't want to put to the trouble of an inquiry statement.
Mm-hmm.
We can deal with what she says.
Uh-huh.
You need to know about timing, but I'm not sure that we need to prepare inquiry statements.
I'm happy to support Mr. Trinick in that approach.
Well, perhaps at least we at the time we could have a statement just setting out who the witnesses are going to be and roughly how long they're going to take. Would that would be helpful?
Yeah.
Yeah. Dr. Hedger.
Yeah, can I just clarify? Are we talking about the statements due?
I'm sorry, your sound's dropped out, Dr. Hedger. Could you ask the question
sorry,
again?
are we talking about the are we talking about the statements due on the 6th of December and the 20th of December now?
No, I'm causing confusion, Dr. Hedger. There's
Sorry, your sound.
yeah, often parties will give a statement just giving at an early stage in the process, giving notice to other parties what their position is, and setting out what witnesses they're going to put forward. So the scope of their evidence essentially, and what witnesses they're going to put forward. That was simply what that's what I was proposing. I think the position is that I think I simply need to know from the parties what witnesses they're going to put forward, and I would like that to happen at the time that responses are made to the additional information. So that there's the deadline that is set out in the statutory notice for the additional information is the 9th of November, but we've agreed that that should be extended by 1 week to the 16th of November. And I'll set all of this out in a note of the meeting, Dr. Hedger.
I think Mr. Nick asked if I was going to make a statement or do a written response for the inquiry. Did I get that wrong?
In respect of landscape, well, I don't think so. I think Mr. Nick was simply expecting it. I would invite you to take part in any part of the inquiry that you wish to, Dr. Hedger.
Questioning that. Anyway,
I'm sorry, I've lost everyone's sound again, I think.
I will prepare a written statement which I will read at the inquiry.
Right. Okay.
So
the other thing is, well, we could it maybe at the end of this discussion, you could just clarify for me, as you're all involved in this process a lot more all the time. Any idea how long the inquiry lasts? I mean, I won't quote you on that, but just to give me some idea for planning.
Well, it depends on how much evidence there is, but I think typically an inquiry would take about 2 to, well, I would guess maybe about, given the number of parties, maybe about 4 days to get through all the evidence. Perhaps it could be a bit less, but I think I would expect about 4 days. Does anyone else have a view on that, Mr. Trinick or Mr. Finlay?
I think you're being pessimistic in this case. If there is lighting evidence, it may be just over 3 days. Without lighting evidence, it's 2 or 3 days, I would think, at the most. But I think to help Dr. Hedger, when she says she'll prepare a written statement to read out at the inquiry, there is the 6th December date for the submission of written evidence for the purposes of the inquiry, and we certainly want all parties to be kept to that, so that we have fair warning of what people are saying about the project that we may have to answer.
Yeah, yeah.
Thank you.
So I would agree with Mr. Trinick, although I'm not in a position to give detailed timings for evidence. It does appear that this is a case that will take, if wildland is not included, 2, possibly 3 days. If wildland is included, 2, possibly 3, potentially 4 days. But
Right.
Will they be
sort of level?
Will there be backup facilities if I mean, I think going back last year, I'd have had problems getting there on a daily basis.
Getting where? I'm sorry, I've lost everyone's sound again.
I'm just asking if there'll be backup facilities for virtual participation, because I think there just could be weather issues in terms of accessing Strathpeffer in January from where I live.
Can we come on to that? I just want to finish off on this section about participation in the different parts of the inquiry. It is an important question. Well, perhaps we have said everything we need to say on.
There's one more point. I think John Muir Trust were objectors to the development, but it appears, as my understanding, and I don't know if this has reached you, that they will not be playing a part in the inquiry.
Right.
Confirm no participation.
Yes.
I'm not sure if something direct has reached you from JMT.
I don't think I've seen anything direct from them confirming that they're not taking part. We certainly haven't had anything from them saying that they are taking part.
Well, it's relevant, sir, because of wildland, obviously.
Yeah.
Presumably they put in an objection, did they?
Yes. Yeah. Okay. Well, perhaps we can move on now to the date and locations of the inquiry and hearing sessions. I think I'd proposed commencing in the week, commencing Monday, 10th January. Given what the parties have said about the length of the inquiry, I think it would be appropriate to start on Tuesday. So Tuesday, the 11th of January. Is everyone content with that? I can't hear. Mr. Trinick, are you content with starting on the 11th of January?
Yes, content.
Yeah, good. And Mr. Finlay and Dr. Hedger?
Yes, content.
Yes. Good. Now there was a question. I had put in the agenda that the kind of default position would be that the inquiry would be virtual. Now that agenda was written before the decisions, I think, or before I knew about the decisions on the Clash and Darragh wind farm. So I've read Mr. Trinick's submission on holding the inquiry in person. Mr. Finlay and Dr. Hedger, do you have any strong views about whether the inquiry should be in person or virtual?
May I just reinforce 2 points?
Well, of course you may.
I'll read my note out. You got my note. The whole point was to avoid making a lengthy item of this. But it's a, dare I say, it's a heartfelt note, this one, about the way in which inquiries should be approached and how they should not be approached. I've laid bare my own thinking in detail on this. I hope that notice will be taken. I think we've experienced this morning, looking at item 6B in my note, that connection issues are a real factor here. We cannot have inquiries which are constantly interrupted by connection issues, unless it's inevitable for COVID or other reasons that there should be a virtual inquiry. However, there was a PEM which has made the point that physical inquiries are strongly to be preferred. This is the one. I think so. If you say no to a physical inquiry, an in-person inquiry in this case, then it won't be a COVID-based decision. It doesn't need to be that kind of decision. It'll be a general declaration that virtual inquiries are to be preferred. I think that's incredibly dangerous, and I'd ask you to resist that, and I'd ask that you have an in-person inquiry. There is no reason why we should not, and the default presumption should be for in-person inquiries for all the reasons I've given in my note.
Mr. Finlay?
Well, so I have split personality in my answer to this question. On behalf of Nature Scott, and we've made Mr. Trinick aware of our position in advance, they are broadly supportive of virtual inquiries. Their experience, for instance, at Glenshara and other inquiries that have been conducted virtually, leads them to consider that they can effectively present their case virtually. On behalf of Highland Council, I adopt a neutral position. They recognise that in some circumstances there may be particular advantages in an actual session, and in other circumstances not. In this case, they don't consider there are particular advantages in a in-person inquiry. I should say, in response to Mr. Trinick's note, it clearly is a heartfelt plea on his behalf. I'm not going to respond to it in detail. We note his points, but the position that I relayed on behalf of both those whom I represent is born of experience forced on us by COVID. But one of the issues that can cut both ways is that for members of the public to attend, sometimes it's easier for them to attend virtually than it is in person. So there are a number of factors to take into account, which Mr. Trinick has forcefully represented some, but that's the position on behalf of the parties I represent.
So can I just come in before you ask Dr. Hedger, because it's relevant to what you're going to ask her?
Yep.
That connection issues aside, and there have been some at her end, no fault of hers this morning. We experimented last September, and you'll remember because you were there, the Clashgar and Rothes 3 inquiry, with a hybrid process whereby those who wanted to attend virtually, for COVID reasons then, but it could be any reason, could obviously do so and give evidence by video link. That is partly why I've suggested the use of a program officer for which the applicant would pay to assist in ensuring that when anyone's giving evidence, those appearing virtually can see the documents in almost real time as they are referred to by other parties. It makes a much more efficient process for those attending virtually. If you can do that within DPEA, that's fine, but I suggest a program officer might help. So I'm really looking for a rerun of Clashgar and Rothes, a large room and enabling social distancing. And we have investigated, there are at least 3 hotels, which I'll name if you want me to in due course, which are available at the time of the inquiry and which have a very large room for the inquiry and sufficient breakout rooms for individual parties to be able to talk in private.
If you could name them just now, that would be helpful, Mr. Trinick.
Well, so one would be that named in your note, which is the Ben Withers Hotel in Strathpeffer. That is obviously has the advantage of being more local. It also has a disadvantage of being an area which is weather affected at that time of year more than others. The 2 other hotels are in Inverness. One is the Kingsmill and the other is the Drumossie. Both of them I know well, and we've established that they've got the right sort of facilities to enable a socially distanced inquiry. And they're available at the time.
Okay. Just before I bring out, well, the Kingsmill and Drumossie, I think that's worth considering. Obviously, some distance from the location. I think well, perhaps the best thing to do is if Dr. Hedger, do you have a view on this? Now I'll go through. I've got a couple of things that I wanted to comment on. Perhaps we could come to an agreement on this. Dr. Hedger, what's your view, or do you have a view so far?
If Mr. Trinick on the the value of public inquiries and the fact that if everything else is open, this is not a public inquiry. It cannot be for COVID reasons, so it could set dangerous precedents down the line in relation to public inquiries and planning. So I agree with him on that point. In terms of actual locations, Strathpeffer is preferable to me, obviously. I mean, I may well have to stay there anyway. For something like this. So anyway, but I'm obviously a minor. I recognise I'm a minor player in all this, so I will just go with what from you. So there we are.
Okay. So my concern about holding an inquiry in person is obviously, you know, but Mr. Trinix mentioned the example of the Murray Wind Farms inquiry held in Aviemore. And that at that time, the confirmed COVID cases in Scotland were running at 100 a day. At the moment, they're running at well over 2,000 a day. Obviously, the situation is very different. There's the you know, the vaccination is much more widespread. And of course, the trend is heading downwards. But we just don't know what will happen before January. I think, you know, in a way, the holding of meetings in person is not entirely, it's not entirely my decision or in my hands. It may be that if the situation worsens again, we will have to review what we're doing. The other difficulty, particularly with the case of the Murray Wind Farms, is that it kind of stands out as an inquiry. We in the DPA we have there's a kind of technical resource issue. We can do an in-person inquiry with webcasting, and we can do a virtual inquiry, but it's actually quite difficult to do a mixed inquiry with in which people are able to connect in by video link and give evidence by video link. I appreciate the proposal to have a program officer. I mean, it wasn't the sole cost in the Murray Wind Farms inquiries. It was also the cost of things like the you know, the hire of screens for people to see the evidence in the room. And that was very expensive. It may be that these things can be dealt with rather more cost effectively, but I doubt it's a different order of cost effectiveness. And I think it was just the hire of screens. I think was some £7,000 in Aviemore. There's also the question of us having the resource available at the inquiry venue to be able to bring in witnesses, and that takes at least, I think, one additional person as in addition to the program officer, which again means additional people in the room where we're trying to keep people socially distanced. So we're creating a bigger meeting by doing it. Having said all of that, I have the example of Clash and Darragh, and what's been done, as I understand it, at Clash and Darragh is that arrangements, that there's an acknowledgement that the DPA are returning to in-person inquiries gradually over time. There is and I think we would need to I think and that it, you know, if an in-person inquiry can be held, then it would be that would be in February. But that since we can't know now what the situation will be in February as regards the COVID emergency, we will need to review that situation later on. And I think if we are going to look at having an in-person inquiry, I think we would probably have to look at reviewing reviewing the position in December to see whether we can still go ahead with having an in-person inquiry. So just in terms of the costs of holding an in-person inquiry, of holding a kind of mixed procedure inquiry, I don't want to make that a sort of long item discussion now. Obviously, I'll have to take that away and discuss it with people in DPA and discuss it with our technical people. But I think I suppose the question for you, Mr. Trinick, is there is likely to be, if the applicant is willing to pay certain costs of holding an in-person inquiry, I think we would have to have a further discussion about what those costs would be. Are you content with that, Mr. Trinick?
It isn't entirely so. I don't think that cost should be the determinant here. There are more important issues at stake, dare I say. I think the cost you're describing in terms of the total costs of the inquiry for all parties are absolutely marginal.
Right.
They really are. It so happens that in Scotland, Section 36 inquiry costs are paid for by the state. Elsewhere in the UK, they're actually paid for by, well, they were,
yes.
Section 36 existed, paid for by the applicant. So there is that difference. And I recognise the need to take a reasonable stance on this, and we will do that. Okay. Let's talk about cost, and let's talk about who pays for what. We're open to that discussion, as we were open on behalf of different applicants were open at the time of Rothes and Flashgower. That I think worked out reasonably. Mm-hmm. We can, of course, following the example of Clash and Darroch, where I'm appearing for the applicant and Mr. Finley's appearing for the council, that we can change to a virtual inquiry at fairly short notice if the need arises. Mm-hmm. I don't see it arising. I think we're in a very different position now with double vaccination than we were in September 2020. But if it arose, we can do it. But I repeat my strong request that with those points in mind, we fix an in-person inquiry, but have the fallback of a virtual inquiry if that becomes necessary.
Mm-hmm. Okay, Mr. Finley.
So yes, obviously maintain the position I do. If there is to be an in-person inquiry, it appears to me that the strong preference must be for the more local location. I think to use hotels in Inverness is understandable, but stretching it. The second point is that it certainly, and it's a default procedure that's been used in a number of cases, of having a further pre-inquiry meeting to determine what the position will be nearer the time when a decision can be taken, and that's a sensible process. Mm-hmm. And both parties who I represent can adapt themselves at short notice to either format. But it's certainly easier to go from in-person to virtual than vice versa.
Yeah, yeah. Well, I understand that Strathpeffer has a room that has capacity for 80 people. I think it would, if we were going to go for an in-person inquiry, it would be very helpful to have from each of the parties attending an understanding of how many people, or what the maximum number of people in the room would be at any one time, so that I'm not putting you on the spot right now, Mr. Finlay, but if you were able to tell me in writing in response to the note of this meeting, what the maximum number of people would in the room would be at any one time, I think that would help us plan and decide whether the 80 capacity room in Strathpeffer in the Ben Wyvis is big enough. It's only 1 meter social distancing. That's the rule now. They've looked at the risk profile again, so we don't have to have quite the United Nations approach that we had in the Murray Wind Farms inquiry. But okay, well, so it would be helpful, as I say, if I could have that information fairly promptly from all of you.
So perhaps to assist your deliberation, if it's only Highland Council, I'd have thought we'd be an absolute maximum of 4, and more likely to be 2 people.
Right.
If Nature Scott are there for a wild land session, and maybe 4, but if I said maximum 5, obviously we'll give consideration to that.
But they presumably wouldn't be there at the same time.
No, so that, but absolutely. That's why I've included that in my maximum. But there might be a maximum of 5, more likely to be 3 or 4. We have an independent witness, Carol Anderson, lined up if the wild lesson session goes ahead. And there may be, say, 2 other people from Nature Scott, or maximum 3 in the background, and myself would make 5.
Okay, good.
So,
Mr. Trinnick, are you able to see right now, or would you prefer just to respond to the note?
well, based on experience to Clashgow, we never had more than 3 in the room. It didn't cause us any difficulties. That is to say, Amy McDougall will be with me from Wright Johnson Mackenzie and a witness, and we'd have a room elsewhere or a space elsewhere where the rest of the team would be, and we'd be in virtual communication through the WhatsApp system and able to communicate. It worked perfectly well.
Good. That's fine. Okay. Dr. Hedger, would it be just yourself, or would you want someone else there with you?
Yes.
Okay.
Yes.
Good. Right. Okay. Well, I think we've talked through. Is there anything else on dates and locations of the inquiry that I've not covered or not thought of? No. Should we move on to the next topic, which is the documents? And I've headed up documents, but it's documents and other forms of submission. What I haven't mentioned in the agenda is the submission date for responses to the additional information, which is now for parties to the inquiry the 16th of November. Then the submission dates for, and I think we said earlier it'd be helpful if people could say what witnesses they were going to lead at the same time. The next is submission dates for documents of 6th December, and from what I hear from parties, that's an acceptable date. That's the date that both Mr. Finley's clients and Mr. Trinnick's client would like. And Dr. Hedger, I think I don't think you objected to that. Is that date okay for you?
Yes.
Good. I've simply asked for witness reports and visualizations and plans to be provided in paper copies. I think all the other documents can be provided electronically. We've had the practice of having the documents compiled in a memory stick, and the applicant has been good enough to do that in other inquiries. Is that a useful? Is that a well? I suppose if there was a program officer, it would be the program officer's. It may be the program officer who is able to do that. Mr. Trinnick, but is the applicant willing to do the compiling of the documents?
Yes, we're happy to, but it would be very useful to know by email from all parties which particular documents they want hard copy.
Right. Okay.
We can prepare whatever they want, but we need to know and have reasonable notice.
Right. Okay.
Can I just clarify? Is that what you're talking about here?
I'm sorry, Dr. Hedger, I didn't catch your question.
Sorry, it was just I might need to have known this. It's asking the whole body of documents in relation to the application.
I'm sorry, you cut out again in the middle of that.
No. Is that stick option, would that cover documents that are in the whole application, or just documents in relation to
the document deadline is for documents to support for you to support your case. So
okay, so it's just in relation to the inquiry. Okay,
yeah.
Thank you.
So in your case, you may be wanting to write a kind of longer witness report, which you can comment on in your evidence to the inquiry.
Yes, I get that. Okay, thank you.
Good. Right. Right. I think I'd mentioned using a single document list. I think that if parties are able to work with the applicant to compile a list of documents, that would be perhaps the applicant can take charge of the document list too. I was hoping that would include, just to avoid duplication, we can use the DPA's library of documents for Section 36 inquiries. I think I sent you all a link to that. So hopefully you've had the chance to have a look at that. I think it may have been used in previous inquiries.
Yes, well, I think Wright Johnson Mackenzie will help the DPA to actually prepare that document list, so they're very familiar with it. So we'll do what is required, and where the documents are in the DPA library, then what you get is a reference number and a hyperlink. That works perfectly well. If they're not on the list, we treat them separately, but we will prepare a draft single document list and circulate and ask for other input and then finalize.
Good. Okay, thanks very much. I've also put down statements of agreed matters. I think parties are familiar with that. Simply, it is best if parties can reach agreement so far as possible on matters that between them, or even defining matters that are matters of disagreement between them. And if any statement of agreed matters can be provided, it would be helpful if it could be provided by the 6th of December as well, along with the other documents. And also it would be helpful if the agreed list of draft conditions could be provided then too. The next submission would be a precognition for people for witnesses. Each witness provides a witness statement called a precognition, which is by law a maximum of 2,000 words, and the deadline for that will be the 20th of December. I think I covered closing submissions as well in the agenda. There will be closing submissions after the inquiry, and what I've asked parties to do, I think the new DPA approach to expedite the writing of reports allows. In that approach, we ask parties to write summaries of their own cases, and I've asked parties to attach those summaries to their closing submissions at the end of the inquiry. Mr. Chinnick.
Yes, so I continue to be bemused by the new policy. I can see what you're trying to achieve to assist in the process of writing reports, but if I'm providing closing submissions, then what you will get from me is my hopefully balanced view of where our case is, having heard the evidence.
Mm-hmm.
That is not the case we might have put forward in the inquiry reports, because that necessarily alters as a result of oral evidence. So can I be quite clear that if I provide what I normally provide, which is a balanced summary of where I think our case is after the inquiry, that will serve the purpose you intend? You don't want a separate document that says, never mind what happened to the inquiry, this was our case to start with.
I think it's for you to put your summary in the terms that you wish, and that sounds a perfectly acceptable approach, Mr. Trinick. I certainly wasn't expecting you to summarise your case as it stands before the inquiry. No.
No, so that's fine. It's just that that's not what comes across, hasn't come across in other cases, or indeed from the DPA's own guidance note 23 on this point. So
I think the suggestion that summaries should be done in precognitions. Yeah.
Yes.
No, I'm perfectly satisfied with the summary in the closing submissions. Yeah. Yeah.
So,
reflecting what's happened at the inquiry. Yeah.
yes.
Mr. Finlay, did you want to add anything on that? I think Mr. Trinick.
No, sir, save to associate myself with Mr. Trinick's comments.
Okay, good. Okay, so Dr. Hedger, unless you want to add anything, I'll move on to the next point.
Well, you needn't cover it now, but I'm not clear what the difference between the 6th of December and the 20th of December statements are.
Right. Okay.
But you could, if someone could advise
No,
me,
I'm happy to deal with that now. Now's the perfect time. In a way, it's a difference of a lot of parties put forward often put forward a lot of documents to support their case, and it's convenient to have those traditionally a number of weeks, usually about 4 weeks in advance of the inquiry, and that was always the case. And each witness, and traditionally witnesses gave their statement, the statement of what they were going to read out at the inquiry, 2 weeks before the inquiry. And this was the precognition. Now, the law put a limit on the number of words in about, I think, a number of years ago. The law put a limit on the amount of words you could have in the precognition. Well, that said, anyway, it's certainly the case that the Code of Practice in Section 36 inquiries puts a limit on the number of words you can have in a precognition to 2,000. And for that reason, simply as a matter of practicality, witnesses started producing longer reports where they felt they couldn't fit all their evidence into a 2,000 word statement, and they submitted those reports at the time of the documents. Now, if you consider that you can fit all your evidence into 2,000 words, then there is no problem. You don't need to submit anything on the 6th of December. You can submit your entire witness statement on your entire precognition on the 20th of December.
Right. Thank you for that clarification. The timing will help me.
Yeah.
As I've got COP26 things in November.
Of course, yes, yeah. It's just if you wanted to say something more than 2,000 words, it would, it should really be for.
Okay, I understand.
The 6th, yeah. Okay. Right. I think I set out in the agenda about site inspections. I was proposing to do unaccompanied site inspections, both at the site itself and at the various viewpoints that have been identified in the landscape and visual assessment. And if parties want to put to me other things that I should go and look at, I'm very happy to do that insofar as I can, and insofar as it's appropriate for me to do so. So I think, again, if you could provide in response to the note of this meeting, a list of viewpoints you want me to go and look at, that would be very helpful. I appreciate that it may be that you'll want to reserve your position to an extent till after the inquiry, and you may want to ask me to go and look at things as a result of the inquiry as well. But it would be helpful if you could give me a list of things you want me to look at now rather than later, so I can make a start on the site inspections.
May I just go in quickly there? We have sent you already.
You have, yes. I
and
meant to say that was extremely helpful. Just a list of how to access the viewpoints themselves in the landscape visual
yes,
assessment.
what we intend to do as well, and we'll do it by the 16th of October, is to provide you with individual visualizations taken from the EIAR for each of those viewpoints. So you haven't got to lug around 17 kg of visualizations on your site visit. The other point, just to make 2 points. One, we have to keep an eye on the wildland issue and site visits, because that's a different issue. Where you may feel the need to be accompanied, but you will need to be, because you need to be driven out there in an Argo cat or similar. And the third issue is we're approaching a time of year when site visits, particularly in the Wivis range, are going to be challenging. And we would urge you to do them as much as possible before the inquiry, bearing in mind your commendable commitment to provide your report to the ministers by May 22, which we've carefully noted.
No. Yeah, indeed. Okay. Good. Is there anything else that comes up on that point that anyone else wants to comment on? Okay. So in terms of a site visit by ArgoCat, I think we'll need to leave that to see whether to determine the degree to which wildland is an issue. But it will be useful to, yeah. I think we'll just have to leave that to determine whether it's necessary. I think that under top heading 13, I have a number of other topics. Just confirms where the documents can be found on the DPA website. The contact being with the case officer, who is Christine Brown, and that her telephone number is set out on the agenda. I will have to make sure that we have the resource for webcasting, but obviously we've discussed the issue of whether to have a mixed inquiry with Mr. Trinick, and we'll need to discuss that further. I set out that I'll produce a note of the meeting and any decisions arising from it. So I'll do that as soon as possible after today, and I'll update the inquiry timetable to reflect that. Is there any other business for this meeting today? Nope. Everyone's silent. I can't actually see your faces. The visuals have gone. But I'll take your silence as there being no other business.
No other business from Highland Council or Nature Scott.
Right. Good. Mr. Trinick, also no other business.
No other business, sir. Thank you very much.
Good. And Dr. Hedger?
No, thank you.
Good. Okay. Well, we'll leave it there. As I say, I'll produce a note as soon as possible. Thank you very much. It's been very helpful.
Thanks, sir.